Good evening to all of you. Welcome to Legal Matters by Sai Baba Sankara. In this video, you are going to be taught about the medical negligence. No doubt, we give the heading as professional negligence, and in this connection, we are going to discuss an important, very important case law. First of all, you all know what is negligence. Negligence is breach of duty of care resulting in legal injury, and when the complainant, when the claimant or the plaintiff claims for compensation, yes, it is a tort of negligence. Negligence is breach of duty of care. Then what is the professional negligence? So who is a professional? You all know I have given an example of local law graduation, that is just ordinary graduation like BCom, then LLB, where you will be trained, legal literacy camps, moot court, and also the monitoring, that is, we will conducting seminars. That is the difference. Please remember, who is a professional? So please remember, professional is a person having a specialized skill in the particular topic. That's why advocates, yes, they are professionals. Doctors, 100% professionals. Engineers, yes, they are also professionals. Chartered accountant, 100% they are professionals. So because they have got the special skill in the particular branch of law. If you take the example of a chartered accountant or a commercial tax practitioner or the son of a clerk who works near a shop, both of them do the same thing. This man is qualified, that man is not qualified. So that is what is called occupation. In other words, profession needs skill, occupation need not. But of course, they also qualified persons, sensitive, skillful persons are there. For example, goldsmith. A goldsmith's son automatically acquires the knowledge. He becomes a professional. It is his occupation. Kumari, all these people, yes, they are all occupation. That is occupation. This is profession. There is another type. It is called avocation. AVOCATION. So if you don't have any work, yes, definitely you will go for the avocation and learn something also. So this difference was explained in the very famous case of Indian Medical Association versus VPShantha and others, 1995. Prior to this. So let us know what happened. VPShantha's husband, he was involved in a road accident. He was admitted in Cosmopolitan Hospital in Punjab state. It was giving free of service. But of course, according to her, due to the negligence of the doctors, her husband died. She filed a case in the Consumer Forum. How the Consumer Forum is competent to take up the case? So during the year 1986, the Consumer Protection Act has come, and there are two things. One is Consumer Protection Act deals with the defect and deficiency. If there is any defect in the product, they will ask you to pay compensation. If there is any deficiency in the service, that like suppose you are scooter mechanic, you did not do it properly, it is service, is it not? You are paying the electricity bill, they are not giving you a correct supply, yes, you are a consumer. Like that, when you are paying money to the hospital or to the doctor, yes, they must show some carefulness. There must be some diligence on their part. If they are negligent, definitely you can file a case under Consumer Forum. Now, if a hospital which is giving free treatment, which is rendering service free of charge, can be taken to task under the Consumer Forum, can it come under consumer? Yeah, no, certainly no, because it's not getting money for its own service. So that is the problem. So these two points are explained in the very famous case of Indian Medical Association versus VPShantha and others. Right. Here, the court explained, any reasonable man entering into a profession, so he must have the requisite skill. Of course, that is a different point. Let us come to only this case. This is Indian Medical Association. In the matter of, please remember, in the matter of professional liability, profession differs from occupations. for the reason that professionals, they operate in spheres where success cannot be guaranteed, cannot be achieved. That's why I tell you, suppose if a patient comes to a doctor, you cannot say, come on, I am going to conduct operation and you will live. Your life will be saved. No? You try to your best. Likewise, a lawyer should not say that, what is this case? I can get it acquitted. Don't say, I will try my best. That's all. Right? So please remember, so medical professionals did not enjoy any immunity. So, and they can be sued in the contract or tort. So you can file a civil case as well as tort case also in the case IMA. But only leverage is that if the hospital is rendering free of charge, service free of charge, that is like government hospitals. And some service organizations, some service like some Christian organizations, they are also do free service. They cannot be challenged under Consumer Protection Act. But once again, there is a litigation. If they collect fees from the rich people and if they serve the poor people, then they are also coming under Consumer Protection Act. So if you know this much, please remember, it will be sufficient. Anyway, a doctor, since we are discussing the professional or medical negligence, a doctor owes a duty of care. A doctor must possess, a professional must possess reasonable skill, and the doctor should exhibit the skill, so-called skill, in a reasonable way. So for this purpose, I want to tell you, the doctor first of all has to find out whether he can take up the case or not. Number two, whether he can administer the dosage of drugs or in the particular hospital or not. Number three, whether the materials available in the hospital are sufficient to go for further treatment like surgery and other things. That means whether oxygen facility is there, whether the so-called Mattu doctor is there, like that. So all these things they have to check up. And if he is a MD, he cannot conduct operation like an MS. So he should decide. First of all, he should decide, then he has to administer. Of course, the result is left to God. We can't say. So if there is any negligence found on these topics, definitely he can be held liable. So friends, in this case, we learned 2 points, important point, IMA case. Number 1, the point is that profession differs from occupation. Number 2, a consumer case can be filed against a corporate hospital or a hospital which takes fees, but not against a hospital which do render or service freely. Number 3, yes, in the case of free hospitals, you can file only a civil or criminal case for compensation. Right? These 3 points are more important. Actually, in the case of the IMA people argued that suppose if a lawyer is just not successful in the case taken up by him, are you going to punish him? Do you mean to say that he is deficient of service? So don't, if at all you want, you have to complain to the Bar Council of India or Bar Council of concerned state. Likewise, if you feel that there is medical negligence, you have to inform to us, that is Indian Medical Association. They will decide whether there is negligence on their part or not. This is also a part of their agreement. Of course, in the class I will give you in detail. For this, because it's a video, it will be sufficient, I believe. Right? Thank you very much.